Disney's lawyers are arguing that if you've ever signed up for a trial of their streaming service, Disney Plus, they should legally be allowed to kill you and you can't take them to court for it. That isn't hyperbole. It's the facts of a new case that you need to pay attention to if you're someone who's ever clicked agree on some terms of service without actually reading them. Jeffrey Piccolo and his wife, Dr. Kanokporn Tangsuan, went out for dinner last October to this restaurant, Raglan Road Irish Pub. It's a Disney World restaurant located in a shopping and dining complex called Disney Springs. The couple chose the restaurant specifically because it was supposed to be quite accommodating to patrons with food allergies, which Tangsuan had. The complaint filed states that the family brought up the issue of food allergies at the start of the meal, inquiring about the safety of specific menu items, had the server confirm with the chef that they could be made allergen-free, and asked for confirmation several more times after that. Even when the food arrived, some of the items did not have allergen-free flags in them, and the family once again had the waiter verify that it was safe to eat and allergen-free, which they did. The family finished their meal and left the restaurant. After 45 minutes, Tangsuan began feeling the oncoming effects of a severe allergic reaction. She administered her EpiPen, but it was not enough. She was taken to the hospital where she died shortly thereafter due to anaphylaxis caused by, according to the medical examiner, elevated levels of dairy and nut in her systems. Her surviving spouse, Piccolo, filed suit in February of this year against Raglan Road Irish Pub and Walt Disney Parks and Resorts US Incorporated. He's seeking $50,000 in damages and a trial by jury. Disney, however, says that the case should not go to court according to a motion filed in May of this year, arguing that the family waived their right to a jury trial when Piccolo signed up for a monthly trial of their streaming service Disney Plus in 2019, a trial he canceled before the month was out. According to the terms of service for the streaming service, any dispute between you and us except for small claims is subject to a class action waiver and must be resolved by individual binding arbitration. This is the kind of overbroad language we all scroll through in half a second on our way to clicking agree. Disney says Piccolo agreed to similar language again when purchasing park tickets online in September 2023. Whether he actually read the fine print at any point, Disney says, is immaterial. Piccolo's lawyers are, of course, saying this is ridiculous and that no reasonable person would assume that a streaming service agreement would be remotely applicable to a wrongful death case years later due to injuries sustained at a restaurant caused by lax health practices. Disney, however, is arguing that they have some kind of lifelong get-out-of-lawsuits-free card should any of their 150 million or so subscribers meet an untimely end at any business even tangentially related to Disney. For context on how far-reaching Disney's claim here is, here's an incomplete list of every business Disney owns. I mean, yes, you're probably aware that they own ABC and Marvel and Pixar and Lucasfilm, the folks that make Star Wars. You might know they also have large stakes in ESPN, the History Channel, also own companies like Steamboat Ventures that invests in startups like GoPro. Most germane to this story is the sheer volume of property companies that are owned by Disney. Why should this concern you? Because if you think that Disney is the only company that cares about this case, you are mistaken. This case might have started as a tragic wrongful death case about one woman and one restaurant, but with Disney's counter-argument, it now has far-reaching implications for other massive corporations that are the kind of company that owns companies that own companies. For example, take a look at this chart. If you've ever bought any type of packaged food product, chances are it's owned by one of only 10 companies. Coca-Cola, Pepsi, Kellogg's, Nestle, Mars. These are the kinds of brands that have all sorts of contests and apps and collaborations with entertainment brands that require you opting in to some type of terms of service, some type of legal agreement with them. Like, did you know that if you've ever taken your dog or cat to a Banfield pet hospital, you know those little vet clinics that you can find in a lot of PetSmarts, then you've also probably signed a bunch of paperwork absolving the Mars Corporation of harm because the M&M's company owns the vet hospital chain. They also probably make your pet's food. If you don't think these types of companies are going to be watching this case for tips on how they could get away with literally causing your death because you downloaded an app or entered a contest or stayed at some property that one of their numerous subsidiaries owns, you are fooling yourself. And if you think this is the only kind of case that's going to come out like this, you're also fooling yourself. As for this case in particular, all parties are expected in court on October 4th of this year. You should be watching this case for developments, because those other companies will be. Hope this helps.